'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Mike D coming down for sure.
So the first requirement that we have is that we owe a duty of care. Now, this is a kind of complicated area. It actually isn't that complicated when you get it straight in your head, but it can be a little bit complicated to begin with. And that's because there's several rules about how you might owe a duty of care. And it's also because sometimes people misinterpret what owing a duty of care means. So the first thing to understand about owing a duty of care is that it's the first step to establish negligence. Just because you owe a duty of care doesn't mean you're negligent. Even if you owe a duty of care and something's gone wrong, you might not have been negligent. Even if you've been careless and you owe a duty of care, you might not be negligent. So this section, this module, this area that we're dealing with, actually really asks you to think things through logically from a legal perspective and apply the test correctly. If you don't do that, you can often end up like thinking you've got the right answer, but you're wrong. Okay, so being logical and following the test is critically important. So let's have a look at what owing a duty of care means and when we owe a duty of care. So owing a duty of care is, as like the term might apply, means, you should take care. You owe a duty, right? You have to take care. But you don't owe a duty of care to everyone, right? And so the person who's injured, who we'll remember from week 3, is called the plaintiff. The plaintiff who's bringing the action because they're injured have to establish that they were owed a duty of care by the defendant. Now, essentially, there's 3 ways you can establish you owe a duty of care. 2 of these ways really come from an act or omission. So what does that mean? It means, well, you did something or you didn't do something you should do, right? There's a third area which has to deal with advice giving, okay? So you can owe a duty of care when you give advice, and that's an area called negligent misstatement. Or you can owe a duty of care when you should do or not do something, okay? Where you should do or where you should do something or you haven't done something you should have. So there's a careless act or a careless omission. Now, within that act or omission, there are 2 different ways that you can owe a duty of care. So all up, we have kind of 3 different ways that you can owe a duty of care. And even in negligent misstatement, there's 2 different tests for whether it's direct, indirect. And so that's what I mean by it can be somewhat confusing. So critically, you can owe a duty of care if it's an established category. So the courts have already decided that this kind of defendant owes this kind of plaintiff a duty of care. Something we'll come to. The second way you can owe it is if you do the standard common law test for an act or omission, right? It's not an established category and it's an act or omission, so we look at the standard test which we're going to apply. The third way is it's not an established category and it's got to do with advice, so it's negligent misstatement. Well, then we have a test for advice that's given directly and a different test for indirect advice, which we'll come to. So that's the way you owe a duty of care. So your job in this subject is to obviously work out what's going on and which of these tests you need to apply as the first step to establishing negligence. It's an established category, you owe a duty of care. If it's not an established category, then the tests of reasonable foreseeability and the salient features of the case are important. That's what we apply. Or if it's about the provision of information or advice, it must satisfy the particular tests around negligent misstatement. This depends upon whether the client is suing the advisor, so it's direct advice, or a third party gave advice, so they're suing the third party. Now, part of the test for owing a duty of care, if it's not in an established category, is the scope of the duty of care. Why is that important? Okay, so I owe you a duty of care as a student, right? But I don't owe you a duty of care everywhere. So if we're out at the discotheque on Saturday night and I accidentally spill a drink on you, causing some harm because I'm careless, I don't owe you a duty of care in my role as lecturer. Right? That's outside the scope of the duty of care of a lecturer. So another way to think about it is when we're in that context, we're not really lecturer-student, right? We're nightclub patrons. And so nightclub patrons, you've got to argue whether they owe each other a duty of care, which is something that you'd have to test. So scope of duty in the real world is very important. It's a very grey area of law. Not grey area, it's a difficult area to determine. And we're not going to be lawyers, but I want you to be aware of it and to understand the concept. Just because you owe a duty of care doesn't mean you're responsible for everything that happens between you and that person, right? It's limited to the scope of the duty of the kind of the duty of care that you owe. So the example that we have here is that we'll learn that occupiers owe entrants a duty of care, but occupiers aren't responsible for every type of harm that can happen to someone who comes onto their property. The scope of the duty that they owe is confined to the condition of the premises, right? And some major activities that occur there. So they're really responsible for what they control, what you could reasonably expect them to control. So the first way you can owe a duty of care is the simplest. It's if there's an established category. What does that mean? It means that there is common law precedent, which means you're bound to follow it, unless the High Court overruled it later, but they're probably not in this area. So if there's an established category, it means the courts have said that this kind or category of person, established category, owes this category of person a duty of care. Now, in the real world, there's a lot of these. We're going to concentrate on a few that are relevant to business. Here they are. Motorists owe a duty of care to other road users. Doctors owe a duty of care to patients. Manufacturers owe a duty of care to consumers or people who use their product, right? That's Donahue and Stevenson. Occupiers owe a duty of care to entrants. So that means if you lease a shop, you're an occupier, and a customer or even a browser who comes in is an entrant. You owe them a duty of care. Professionals owe clients a duty of care. Employers owe employees. Directors owe a duty of care to the company. Agents owe a duty of care to their principal, which becomes important in week 9. So a question that will get asked, do you need the case names? Well, I'm going to throw it back to you. What is the source of the law? For owing a duty of care under established categories, it's the case. So yes, you need the case name in this instance. You'll notice that we've put 2 there. They're probably the 2 most relevant to business settings. Okay, so if it's not an established category, then what do we do? That's for our next video, where we're going to look at the general test for owing a duty of care.